Good to go? Okay, let's do it. I want to thank all of you for being here today. Javier Becerra, Attorney General for the state of California. Happy March 1st. I'm here to talk about our report that we have now released publicly and should be now in the hands of every member of the state legislature, the administration, and hopefully now in the hands of the public as well. Before I get into the report, I'm going to acknowledge quite a few people, some of who are here, who make it possible for us to do the work that lets us issue a report like this in trying to help keep Californians safe. Phil Ferrari, Special Assistant AG on Public Safety Affairs. Surat Adipit, Director of Office of Legislative Affairs. Ashley Ayers, who's a Deputy Attorney General in the Office of Legislative Affairs. Chief Kevin Gardner, who is the Chief of the Division of Law Enforcement of the Department of Justice. John Marsh, who is our Assistant Chief at DLE. Marty Horan, who is actually standing right next to John Marsh, who is the Director of the Bureau of Firearms, and so he is the main man when it comes to the work that's done under the APPS program. Brent Orrick, who is the Assistant Director of the Bureau of Firearms. Blake Graham, who is a Special Agent Supervisor, Bureau of Firearms, so Blake is out there with his team day in, day out. Lauren Ishii, who's a Criminal Intelligence Specialist within the Bureau of Firearms. Dr. Randy Chance, who is the Director of our Research Center here at the Department of Justice. And Dr. Steve Raphael, who is a consultant with the Division of Law Enforcement. Behind all of the numbers that we're going to talk about for 2018, for the APPS program, the Armed Prohibited Persons System program, and this report that we're issuing, we're really talking about communities and the importance of keeping all of our families in these communities safe. Let me give you a quick example of what I'm talking about. An APPS seizure that took place last year in the city of San Diego. Our APPS team investigated a subject who was prohibited from possessing firearms due to a domestic restraining order, violence restraining order that had been issued by a judge because of threats that he had issued, threats of violence he had issued against his spouse during divorce proceedings. Our team acted quickly, creating a game plan and contacting local agencies once we found out that this individual had a restraining order and had become, in California law, a prohibited person from possessing weapons. After 3 days, our 5 agents conducted a search warrant on the subject's residence on January 25th of 2018, expecting to find 7 handguns which he had registered. They found the 7 known APPS handguns and 9 rifles, 2 shotguns which had been loaned out to the subject's friend, and approximately 3,500 rounds of various calibers of ammunition, along with 147 magazines that were found inside the residence. Our agents also uncovered various types of military flash grenades, smoke grenades, illumination flares, and small detonating devices in the subject's garage, all from one individual who was prohibited from owning firearms. Take another example. Happened this past June 2018 in the city of Laverne. Our agents followed up on a case of an individual who was prohibited from owning a firearm due to a misdemeanor domestic violence conviction. Again, within hours, our agents worked up a case and contacted local agencies to notify them of the operations plan. 6 agents reported to the subject's residence. In this case, our agents made the contact and were able to verify with the Laverne Police Department that the weapon had been seized from this subject, but it had not been reported to us, to the automatic firearm system that we possess, so that we would know that the weapon had been turned in. In fact, the weapon had been confiscated 10 years before, and the following year after the 10 years ago had been destroyed. We didn't know that. So we had to work up the case because we wanted to make sure a prohibited person in fact, did not possess this weapon, especially given that he had been convicted of a misdemeanor for violence involving domestic affairs. This is the kind of work that our men and women of the APPS program do day in, day out. When it comes to keeping guns out of the hands of dangerous people, California has figured it out, and we make a difference in what we do. And we're the only state in the nation that does it. Since 2006, our Armed Prohibited Person System, or what we call APPS, has cross-referenced firearm owners against criminal history records, restraining orders, and mental health records as well. We are the first and only state, as I've said, in America to establish a system like this. And it works. Every day, our agents investigate and contact people who own firearms but are now prohibited from possessing them because of a felony or a violent misdemeanor conviction, or because they are seriously mentally ill, or they have a protective order imposed upon them by a court. Our agents, all they work on are these APPS cases in this team. During the first half of their shift, each of our teams review a packet of 10 to 20 individual cases and go over the operations plan for each case. They focus on specified areas, oftentimes organized by zip code. In the second half of their shift, they head out into the field. Maybe no one is home. Maybe the subject's spouse says the subject is at work. So our agents go on to the next address on their list, day in, day out. We average some 50 field agent positions in the Bureau of Firearms dedicated to the APPS program. They are distributed among our 6 field offices. Those 50 agents cover 58 counties. That's less than 1 agent per county, and no team acts with just 1 agent. You need to have a team of several to do this work. We couldn't do it without our agents' tough and dangerous efforts behind the scenes. And today, I'm here to highlight some of those efforts with the results of our 2018 annual report on APPS. Our 50 agents who do this work make an estimated 22,000 plus contacts as part of the APPS enforcement work. They removed more than 10,000 individuals from the APPS list. They seized a total of 2,290 firearms, including 1,044 guns that were previously unknown to us and not part of the registered weapons. All of these guns are now off the streets thanks to the efforts of our agents. The progress we've made since 2013, when additional resources were allocated by the legislature for the APPS enforcement program, is striking. We began that process with a backlog of more than 20,000 individuals in our database in 2013. Only 538 of those cases remain active today. As I've discussed to members of our legislature, we have an opportunity to support our agents and make a strong program even stronger. For one, taking guns away on the back end is inefficient. Wouldn't it be more efficient to confiscate firearms from convicted felons before they are set free, rather than have to have our teams go out and find them after they've faced conviction, have been released? There are opportunities here to explore possible solutions with local law enforcement, our courts, our parole officers, and certainly the legislature. Second, we're learning some other things. Our agents deserve competitive wages and benefits. The Department of Justice entry-level special agent salary is 44% below the statewide average for entry-level peace officer positions, despite the Department of Justice's higher education requirements. Every one of those agents that goes out there to do this work has a college degree. At the Department of Justice, we need the resources to make our officers competitive when it comes to salary and compensation. That's the only way to keep attracting and retaining the top-notch agents that we need. Third, I want to mention one other thing. We could use more consistent cooperation from local law enforcement agencies, especially when it comes to keeping firearm records updated. I mentioned the case in the city of Laverne. Had we been notified when the weapon was first confiscated some 10 years earlier, we wouldn't have had it have our several agents work up the case, get ready, and then go out, only to learn that the weapon had already been confiscated. And finally, I think it's worth mentioning, our data systems are in need of modernization, and that is an understatement. We need technology that keeps up with the changing times, because the work that our agents do is too important to not be done as quickly and as efficiently as possible. These investments in apps are investments in the safety of our community, and they're essential to building on the strong record of success that our agents continued in 2018. With that, I want to just once again acknowledge the work of the Bureau of Firearms Special Agents who day in, day out, go out and retrieve weapons from people who no longer have permission to own them. How many lives they've saved? We'll never know. But I guarantee you, those thousands of firearms that are no longer on the streets in the hands of dangerous people saves lives for all of us. And so we want to send a real loud applause to all those agents who have done all this great work. Before I take questions on that apps program, I want to mention one other subject, and I'll take questions on this subject if you have any as well after we discuss the apps program. There's an issue that is now before us in that a Public Records Act request was made of POST, the state's Peace Officer Training Center, where POST, as a result of a Public Records Act request, provided an entity with information which is by law confidential. When it comes to police personnel records, I think it's important for me to restate something. And I've said this both publicly and I've said it in our legal filings as well. In fact, I just said it in a legal filing last week. I believe under the law, records that predate January 1st, 2019 should be released of police personnel. A law that was passed last year and is now in effect in 2019, based on SB 2014, now requires that some of these police personnel records be disclosed. But there is an outstanding question in the courts as to whether that includes records that predate January 1st, 2019. That should be settled fairly quickly. And we've taken the position with regard to the peace officers who work at the Department of Justice that we're going to make sure that we do it right when it comes to disclosing what is otherwise or has been private, confidential information. And so while we have a law in place and we want to make sure that we abide by it, we want to make sure we're complying with it the right way. And the court should give us that determination. Because when it comes to someone's private, personal information, you don't get a second chance to get it right if you disclose it. You have to do it right the first time. There's also a separate issue I'd like to mention as well relating to police records. There's a false narrative that's circulating out there about police officer conviction records. Under the Public Records Request Act that I mentioned of a particular organization, records were released to POST by POST to this organization. And my office, which is responsible for maintaining the automated criminal history system, which contains a lot of these records, is involved because after providing these data to POST at its request to make determinations about police eligibility and qualifications to be hired or to retain their service in law enforcement, was a job that we were obligated to do at the request of POST to provide this confidential information. POST inadvertently, after a request, a Public Records Request Act, sent this information to an entity that requested the information under a PRA. That information is by law unauthorized for disclosure, except for disclosure to those who have a legal right to possess it, as POST has that right. But the entity that received that as a result of the PRA request submitted to Post does not, by law, have that right to possess that information. That database information that we sent to Post contains every California's criminal history, including arrests and court proceedings. It includes information that may have never led or about an individual who may never have been convicted of a crime. Simply because you are arrested does not mean you have been convicted of a crime. And certainly most people would not consider that criminal history to have been arrested, especially if the arrest was not one that was grounded. I should mention that this database does not only pertain to peace officers. It includes information on all Californians who have had some contact with our criminal justice system, as I mentioned, if you might have been arrested. This database is statutorily confidential. Post uses information from this database to ensure peace officers meet our statewide minimum standards to serve as a peace officer. Nowhere, I want to make this clear, nowhere have I threatened any individual when it comes to how they should conduct their business, including those in the media and in the press. I have simply asked everyone who is demanding to see the records of thousands of Californians to consider the rule of law and the right of these Californians to their privacy. That is a request, only a request. We've always strived to balance the public's right to know here at the Department of Justice with the need to be transparent and to protect an individual's right to privacy. In this particular case of the inadvertent release by Post of confidential information to this entity, information from that database that Department of Justice possesses that's required by law to be confidential was released erroneously, jeopardizing personal data of individuals across our state. No one wants to shield criminal behavior. We're all subject to the rule of law. That's why I'm standing here today answering questions about any and all matters relating to the work of the California Department of Justice. For those in journalism who seek to report the truth, we want to be supportive. And this is the truth. Releasing the criminal information of thousands of people across California can affect their families' well-being, and that's a big public safety concern. That database could have your criminal history in it if you were arrested, even if it was an arrest that should have never occurred. It is my job as the Attorney General to protect you and all Californians and the rule of law, especially when it comes to your privacy.